make this file available to our students within the university platform, okay?
Excellent.
So we are now recording the lecture, and I would like to pass the mic to Professor Pedro Martinez-Fraga. Fraga, I'm sorry, after this brief introduction. Pedro?
Well, first of all, thank you so much to you, Christian, Professor Carneiro, and to Professor Do Armaral. It's a privilege to be here. It's a privilege to be at the university. And I want to thank all the students for making time to come here. As I said at the very beginning when we informally met, I would like to take this opportunity to invite all of you, if you have any follow-up questions, ideas, comments, or want to have conversation, on this subject, please feel free to call or to write. My name, address, everything is in the public domain, so that should not present any type of obstacle. And I want to give you, first of all, a little background before we get into the public purpose doctrine, which is the subject matter of our talk today. And the background I want to give you has nothing to do with the public purpose doctrine as such. It has to do with thinking and with analysis and with challenging untested assumptions. About 600 years before the Christian era, Anaxagoras was incarcerated. And some of you may know that Anaxagoras, the mathematician, was incarcerated because he said that the moon did not have its own light, that the moon's light was borrowed from the sun, which happens to be true today. And that caused a number of problems. When he was in prison, however, the mathematician, one of the things that he did was he wrote a challenge to the world as such at that time. And a challenge that he himself undertook and that he never met. It was conceptually impossible for him to meet it. But this was the challenge. The challenge was to have, for any given circle, to construct a square using a ruler, a straight edge, and a compass, such that the area of the square would equal the area of the circle. And this was done with Euclidean geometry. Now, let me tell you something. This challenge became a universal pastime throughout the centuries. And it was not until the 19th century that this challenge was actually met. And the only reason it was met so many centuries later was for one reason. People started thinking about the problem under different terms, under a different geometry. They discarded Euclidean geometry and they embraced non-Euclidean geometry, a geometry where parallel lines meet, where a right angle is less or more, but never 90 degrees, where a triangle is invisible. And when there was this paradigm shift, it was possible to construct a square having an area equal to any designated circle using only a ruler and a compass. But it took many, many centuries to get there because everyone was laboring under false and untested premises. And no one, until the 19th century, the 1800s, had the courage, the intellectual courage, to think differently and to question whether the elements that were being used were the proper conceptual categories. I think Anaxagoras is very relevant for all of us, both practitioners, academics, and students, because in thinking about public international law, I think that we need to start conceptualizing differently, and we need to start opening our minds to different ways of understanding public international law, if public international law is really to redeem its promise to contribute to the betterment of society. Now, I've brought the public purpose doctrine to your attention and as a subject matter of this talk with you, because the public purpose doctrine is a doctrine that is ubiquitous. It is ever present. But the public purpose doctrine, notwithstanding being ever present, is a doctrine that is completely misunderstood and conceptually, in my opinion, bankrupt despite its prominence. And as I will share with you here today, the bankrupt nature, the conceptually bankrupt nature of the public purpose doctrine has very, very serious consequences that affect all of us, beyond just the public international law of investment protection. Let's first talk about where we see the public purpose doctrine in the international law of investment protection, even though obviously it's not limited to that body of law and the jurisprudence, if you will, and the writings that are spawned from public international law of investment protection. We see the public purpose doctrine playing a critical role in what is another paradox that resembles, to a large measure, the squaring of the circle. Every state has an obligation to engage in regulatory, legislative, executive, and judicial sovereignty. A state must do this if it is to survive. But every state also has the equal normative imperative of equal hierarchy and of equal standing from an obligations perspective to protect foreign investment. Regrettably, often these two obligations that are held in pari materia conflict with each other, and a state's obligation to regulate, to legislate, to undergo executive decrees and to pass them comes into conflict with investment protection obligations that the state has. And at that point, the obligation causes foreign investments to suffer or altogether to completely disappear. Now, public purpose is endemic to this area of the law because under public international law, an expropriation has four elements that you're familiar with. And one of those elements is public purpose. In other words, as you know, a state has a right to expropriate, but that right to expropriate must be a legitimate right. It must be to expropriate the assets of a non-national. It must be a legitimate right. It must be exercised in accordance with a standard. Regrettably, the right of a state to exercise this right in accordance with a standard often has been conflated, wrongfully confused with another proposition, which says that a state can determine the standard that applies to the expropriation of a non-national. Now, obviously, that's a fallacy. In fact, it's the contrary that's true. A state is bound to follow four elements. And those elements are very clear. The taking must not be discriminatory. The taking must be in keeping with due process. There must be compensation to the taking, and we'll talk a little bit about that later. And finally, the taking must be for a public purpose. Because public purpose finds space, critical space in this standard, that means that we find public purpose in at least 4,000 bilateral investment treaties around the world. Now, the truth is, of those 4,000, less than 3,000 are in force and in effect. But the public purpose doctrine is embedded in all of them. Now, we also find the public purpose doctrine in other places. We find the public purpose, and very, very important in these other places. We find the public purpose doctrine in the law of international human rights, and we find the public purpose doctrine in, for example, the doctrine of permanent sovereignty over natural resources. We find the public purpose doctrine in concepts such as sustainability. So we find the doctrine everywhere. Now, if in fact we find the doctrine everywhere, what does public purpose mean? What are the elements of this doctrine? And I ask you to reflect on that. This doctrine that is everywhere, that appears to be so critical, what are its elements? When do we know that a state has correctly and rightfully and lawfully exercised public purpose? And what is the effect of public purpose? Well, let's step back for a second. Before we keep looking at the effects of public purpose, let's just make sure we know what we're talking about by pointing out what public purpose is not. We know that public purpose is not public policy. In other words, for example, an arbitral award may not be adopted, may not be given force and turned into a judgment by the courts of a particular state, because the courts of that state may determine that the award is against its public policy. And that may be a public policy not to have arbitral awards, having a subject matter with domestic law or with criminal law, or maybe in some jurisdictions with antitrust law. And maybe for these reasons, the public policy is such that the award cannot be domesticated. It cannot be enforced. Not necessarily set aside, but in the enforcement state, it cannot be enforced. That's public policy. That's not public purpose. That's very different. Or a contract between two individuals may be against public purpose. I'm sorry, public policy. For example, let's assume that Professor Carneiro and I enter into a contract to assassinate Professor Do Amaral. Well, it's against public policy. It doesn't matter that all the elements of the contract are met. The public policy of the state of Brazil will not recognize that as an enforceable contract, such that if it was my obligation to shoot Professor Do Amaral and I fail, Professor Carneiro cannot bring a cause of action for incompetence or breach of contract, more precisely, against me. The courts will not recognize it. That's public policy. That's not public purpose. So now the real question remains, what is public purpose? We've already said where we find public purpose, but what is it? And I will tell you one thing that is extremely important that I think you're going to find to be somewhat of interest. And it is that public purpose is nowhere defined. You're right. You've heard me correctly. There is no definition of public purpose anywhere in the world. What can this deficit possibly mean? If there's no definition, then what is public purpose, which we see everywhere? Well, let me tell you what I believe is public purpose. Public purpose is defined by the acts of the state. The state determines what is public purpose. That is the nature and the substantive import of the public purpose doctrine as we see it today. And what that means is that with respect to public purpose, it is the who and not the what that defines it, meaning that it is who says it and not what it actually is that defines it as a public purpose. And I submit to you that this state of affairs is not a sustainable one. And it's not a sustainable one because what public purpose does in the public international law, let's just narrow it to investment protection. And a large part of what I do is international commercial arbitration and international arbitration, investor-state disputes, defending states, and also bringing claims against states. And in this area of the law, public purpose is very important because it means that if there is a public purpose that is defined by state action, by the state itself, then that means that the regulatory sphere, the executive sphere, the legislative sphere, and the judicial sphere of the state is boundless. It's not constrained. You saw that public policy constrained. Well, public purpose has the diametrically opposite effect. It amplifies the sovereignty of the state. And if it amplifies the sovereignty of the state, what is the corollary? What happens to the individual rights? The individual rights of persons, of citizens, of nationals, of non-nationals in the state is diminished. They're inversely proportional. Private rights and public purpose. So that if we have a public purpose that is defined by what the state does, then we are in effect providing the state with an unbridled license to act as it sees fit, because no state will say, we are doing X, Y, and Z, but of course it's not for a public purpose. What else do we find in this public purpose doctrine? If the public purpose doctrine is, as I am suggesting to you that it in fact is, a subjective, self-judging standard, then the public purpose doctrine, as it now stands, is subject to a test that is always met. If the state defines the act itself through its actions, through any of its branches, then the public purpose doctrine itself will always be met every time that the state acts. And there's no accountability for the state. The state is only accountable to itself. There's no challenge to the public purpose doctrine or to the exercise of that doctrine. I want to tell you something that is remarkable. In the United States of America, there is an institute called the American Law Institute, of which I am a part, and I'm proud to be a part. The American Law Institute, among other things, restates, or it's not charged exactly with clarifying the law because it doesn't have that ability, but it makes public what the law, what the common law is in different areas of the law. And there is such a thing as the United States law on foreign relations. And there are two restatements of the law stating the law for the practicing bar, academics, anyone interested in the law. And there's a restatement called the second restatement, which dates back to 1965. And there's a third restatement that dates to 1987. And that's what, about 25 years or 23 years, whatever. Both restatements try to explain what public purpose means in international law, in public international law. And both restatements during this time frame from 1965 to 1987 say basically the same thing, that it is a subjective standard that cannot be challenged through objective conceptual categories, and that this subjective standard merely reflects the subjective acts of the state. In other words, when we look out and we try to see the public purpose doctrine, there has been no change, and the doctrine is virtually rendered an illusory doctrine. It's there, but it's really meaningless from the point of view of, for example, a claimant in an investor-state arbitration, because there is no criterion to challenge any act of state once the state claims that it is for a public purpose. This is a remarkable situation. So where does this leave us? I think it leaves us with at minimum 4 points that I want you to start thinking about in the context of public international law, pertaining to the public purpose doctrine and beyond. And this is part of that change that type of change that took place in the 19th century when Anaxagoras's challenge had to be reconceptualized. And I'm asking you and us to reconceptualize public international law, but in ways that are much less dramatic, but of equally revolutionary consequence. Here's the first point that I want to share with you that I think is extremely important. International law must be true to its own principles. What does that mean? That means that public international law must be an objective law, and that its policies of being international have to be abided by. This means that public international law should be primarily free from the constraints of domestic law, of domestic contract law, of domestic tort law, and of domestic real estate law. This doesn't mean that the national law of states and concepts, such as the ones pertaining to these different areas of law, should be completely removed from public international law. No, it means that they are secondary in nature, that they are subordinate to other considerations of public international law. Why do I say that? I say this because, for example, in public international law, when we see, and in particular in the public international law of investment protection, when we see limiting factors or qualifying factors such as umbrella clauses that raise domestic disputes to the level of international disputes, when we see limitations periods that are really constructed from domestic law and have very little relevance to the policy objectives and workings of public international law, when you have most favored nation clauses that really denaturalize the purpose of a negotiated treaty between parties and opens a Pandora's box of possibilities, both substantive and procedural, that can be used in a given dispute, I submit to you that these are legacy concepts that have their origins in two places. First, in a pre-globalized society, in a society that is based on a paradigm of independence and not in a paradigm of interdependence. This is critical. This is a territorial approach that no longer is relevant. Public international law is a transnational law that is dependent upon a community of nations and upon multilateralism, and not unilateral type of constructs or international law, the law that regulates the relationship between two or maybe three states. That's the first point that I want to share with you. And as part of that, you're asking, well, what elements then are you saying as part of that first point, that international law must be true to itself and it must foster international law elements and objectives? You're saying, what then are the primary components of this international law if it's not the law of contracts, not the law of real estate, not the law of torts? What is it? Simple. Microeconomic concerns form part of this law, certainly in the context of investor, of the protection of foreign investments, the international law of foreign investment protection, to be more precise. Macroeconomic rules as well. Proportionality. Public international law in this space should be proportional and should not be an all or nothing proposition. The distributive effects of public international law of investment protection also must form parts of the element of that law. Let me give you a brief example. In one of the cases against the Czech Republic, the award that issued in favor of the claimant in that case, and by the way, I represent both claimants and states, as I said before, so I have no dog in this fight, but I want to be as objective as possible. One of the awards that issued in one of the Czech Republic cases was larger than the budget of the Czech Republic for healthcare for several years. Now, this has to be taken into account. Also, another element, in addition to microeconomic, macroeconomic, proportionality, distributive effects, another concern that must form part of the elements of public international law generally, and should also form part of any analysis of public purpose, is the chilling effect that a particular construction of an investment treatment protection standard may have on additional investments, or on the extent to which a state may be seen as a haven for certain types of investments, because the perception is that the state will not enforce certain types of, for example, environmental laws. All these issues have to be taken together to be able to understand fully and comprehensively what public international law's objectives are, and what it is, how it is that treatment protection standards and public purpose in international law, what factors really underlie these elements, these doctrines. And of course, we also make room, but in a secondary position, for principles of domestic law, of contract, real estate, corporate, you name it. Now, if you step back a little bit and you ask yourself, well, what is this guy talking about when he's making the proposition that somehow public international law has to be completely revamped in this way? What is he really saying? Let me try to say what I'm saying even more precisely, or precisely in the first instance, if I haven't been successful. Let's think about treatment protection standards, such as expropriation, and the four elements that we talked about in public international law. What I'm saying is that ascribing a model of causation and liability to public international law, which is what we have in domestic law, does not work, because those models of liability based on causation cannot identify instances in which a state exercised its regulatory sovereignty illegally or wrongfully. Those paradigms of causation cannot point to instances where a state exercised its executive sovereign authority wrongfully, or its judicial authority wrongfully. They're not meant to do that. The law of contracts was not meant to engage in such factual findings or analytical endeavors. And the same holds true for the law of real estate, and the same holds true for tort law. It doesn't work, and it cannot work. It's apples and oranges. It's a test and grafted upon a problem for which it is not suited nor was ever designed. So that's the first principle. The second principle is this area, this point that we referred to most recently. While every state has the right to expropriate nationals and non-nationals, it must expropriate the investments of non-nationals in accordance with a given standard. And no state can at all make up or craft its own international standard for expropriating nationals. It just simply does not work, cannot work, and it's not the state of the law. In fact, the state of the law is completely different. We just talked about 4,000 bilateral investment treaties that have a very clear and defined standard for when it is that a state may expropriate a non-national. 3, in applying the public purpose doctrine, we say that a state must demonstrably establish why the doctrine as applied fits into a public purpose, and that the state has a burden to prove affirmatively that what it is doing and claiming to fall within the ambit of public purpose, in fact, is a public purpose. And fourth, what is the role of public purpose with respect to international human rights? If we have a public purpose doctrine, as we have it today, a failed public purpose doctrine, then any state can claim to abolish, infringe upon, or modify human rights in the greater interest of public purpose. The state says we are now suppressing a freedom of assembly for the greater public purpose of order. We are now prescribing that children after the age of 12 really must have primary loyalty to the state rather than to their natural parents or parents, because this is for the better and the common good. The state can use this self-defining subjective public purpose standard to modify and infringe upon human rights. Now, obviously, this is an unacceptable, again, status. We cannot live in a world where a state is licensed by its own concept to infringe upon human rights. Now, the public purpose doctrine that we are advocating for and that we're calling for and that we will further flesh out and define during the course of this talk with greater detail and in greater detail is one that is objective, one that is not self-judging. It's one that cannot be politically driven. It's one that has to meet a burden of proof and that has to be substantiated. This type of objective public purpose approach with very, very, very particular elements to it is one that does two things. First, it limits the state's encroachment into human rights, among so many other things. But secondly, in the context of human rights, it also helps establish a hierarchy of human rights. And here's what I mean. While obviously you can envision a scenario where a state rightfully limits perhaps even something as crucial as freedom of speech or freedom of assembly under particular circumstances, certainly you cannot, or I challenge you to envision a scenario where a state, based upon an argument of public purpose, can somehow limit a person's right to be free from torture, or can somehow limit a person's right to have children, or can really limit a child's right to have rights or to have a name. Here we see that public purpose completely fails. It cannot justify limiting these rights that are akin to jus cogens. Here we see that an objective public purpose does the opposite of what the subjective public purpose does. It says there are certain human rights that the state under no circumstances can infringe upon. To be free from torture, to be entitled to health care at a minimum level, to be free from suffering. The state cannot limit these basic rights. The state cannot infringe upon jus cogens. If in fact it's doing so based on, or purports to do so based on an objective public purpose standard. So we see that the legacy public purpose that we have really is one that does not work at all. And in fact, it has been ignored. I will tell you that if you look at ICJ cases and the ICJ's predecessor, you will find that public purpose is completely ignored. For example, in the case between, which was the first and the last nationalization case that the ICJ ruled upon, the case between the UK and Iran, that case, the claimant did not even assert, did not even allege that Iran's expropriation or nationalization of the UK oil fields were in violation of a public purpose. Of course, that case was dismissed for lack of jurisdiction. But when you look at the record as I have, you'll see that public purpose is completely ignored. Similarly, in the Libyan oil cases, public purpose is not even taken into account. In the Iran claims tribunal cases, public purpose, no one even debates public purpose. They concede public purpose to the state. Why? Because there's no room for debating. It's defined by the acts of the state without more. Now you're asking, from a historical perspective, where does this subjective public purpose comes from? We've looked at it, and I will abbreviate the analysis somewhat for you. We looked at public purpose and the origins of public purpose, and we feel that public purpose, the public purpose we have today in public international law, is the identical public purpose that we had back in the days of Homer, when there were no states, when there were city-states. And we find that the first time that public purpose is discussed in a juridical, quasi-national, if you will, because these are city-states, context, was in connection with a word that Homer uses a lot, which is the word demos in the masculine, demus in the feminine, which means slave. Yes, slaves. And that word historically has been loosely translated to mean plunder with feet. And the public purpose doctrine was first used, and there's reference to it, because it was used by one city-state to justify slavery over the people from another city-state. And that word demos, let me share with you, morphed. And it became a word called anthropodon, which means literally chattel with feet. And that word anthropodon, which is very familiar with the words that we know like anthropos or aner, that word was concisely used and associated with the justification of the taking of chattel with feet because of a public purpose of the state. So we see that the Greeks, city-states, looked inward on a territorially based model, and they used the territoriality of the politics of the city-state as being supreme, as justifying even slavery. And there is one exception to being able to justify slavery in Greek, in the terms of the Attic Greek and the Homeric Greek, and that's when we find the word called sponde, which means treaty. And if there was a slave or a potential slave, a person to be enslaved, that came from a state that was deemed to be ex sponde, with which there was no treaty, rather than en sponde, then there was an exception. If it was en sponde, if we had a treaty with that city-state, there was a complete exception, and there would not be, public purpose would then have to be subordinated to the actual treaty. You know, there's a book called The Elements of International Law. It was written, I think, in 1836 or so by Henry Wheaton. And he talks a little bit about this issue. And even though I don't like reading from notes too much, I want to read from these notes to give you a little bit of the sense of what he says. And Wheaton writes as follows. He says, quote, Thucydides has correctly stated the leading political maxim of his countrymen, quote, that to a king or a commonwealth, nothing is unjust, which is useful. End of citation. The same idea is openly avowed by the Athenians in their reply to the people of Milos. Aristides distinguished in this respect between public and private morality, holding that the rules of justice were to be sacredly observed between individuals, But as to public and political affairs, a very different conduct was to be followed. He accordingly scrupled not to invoke upon his own head the guilt and punishment of a breach of faith, which he advised the people to commit in order to promote their national interest, their public purpose. Period. End of citation. The doctrine of public purpose, ladies and gentlemen, has not changed in the last 3,000 years. Because it has not changed at all, we would we would prefer for it to have the following elements that I think are completely critical to it. And these elements are what we call a non-exhaustive list. And we feel that it's, the only way really properly to be able to go forward. First of all, public purpose cannot be self-evident. It has to be subjected to discursive reasoning. It cannot be an intuitive type of doctrine. Second, just because an activity is public in nature, purpose. Third, it cannot be a self-judging doctrine, meaning that a state cannot judge what is a public purpose. It cannot have that power. Fourth, it cannot be an either-or situation or doctrine. It has to be a flexible doctrine. Five, many sources can be helpful in formulating the doctrine, like, for example, foreign investment protection statutes of states. We can look for doctrinal help in formulating public doctrine from multiple sources, not just 3, 4, 5, or a handful of sources. Six, it is important to harmonize public purpose. Certainly, there must be only one public purpose, at least within the meaning or within the constraints of one particular subject matter of international law. Seventh, public purpose cannot be binary. It cannot be an either-or situation. There must be proportionality. Eighth, there has to be a hierarchy of public purpose. Not all public purpose can be the same. Ninth, public purpose should not extend to conduct that is mostly political in nature, such as, for example, regime change. This doesn't work. States should work to define public purpose, or to at least draft a standard for public purpose. We understand that a definition, by definition, is a limited, a rendering finite what otherwise would not be finite. But a standard, such as what existed in Article 1101, subsection 4 of the NAFTA, where there was a such as and then examples given, that is helpful, and that also provides with great flexibility. 10th, the states, or 11th, I'm sorry, states should have a burden of proof to demonstrate objectively why it is that a particular action falls within public purpose. Now, let me just tell you in closing something that is critical here. I once gave a version of this talk in another university, and a person there who was the former dean of Yale Law School, a great guy, Harold Cole, said, wow, you started this book with a reference to Immanuel Kant's perpetual peace, but you ended the book with Hobbes in despair, thinking that there's no way that we will ever get anywhere. And, quite frankly, with all due respect to Professor Cole, he misinterpreted how we ended the book. We ended the book in a very positive note, a note that actually you find in Ovid's Metamorphoses. If you may recall, some of you, in that book, there's a moment where Aeneas, the protagonist of the book, wants to meet his father's spirit in the underworld. And there is like an angel or a type of spirit ghost in front of the underworld, not allowing anyone to go in. And Aeneas turns to the ghost, to the spirit, and says, I want to see my father. And I'm begging you for access just to see him, just to see his shade. And the spirit turns to Aeneas and says, Aeneas, you've always been a brave man. You've always risked your life for others, and your sword is the sword of a hero. Of course, you can come in here and see your father's shade. And he says, and the reason why I'm granting you this permit, and Ovid says as follows, says, because nulla via in via virtuti est. Because for virtue, no path is impossible. Now, what I'm asking you to do here with public purpose and beyond, with treatment protection standards and the entire law of the protection of foreign investment, is very, very difficult. But it is the right thing to do. And just because it's very difficult, it doesn't mean that it is impossible. And with these last words, I want to thank you for being so generous and so patient in hearing this diatribe out. Thank you so very much.
Thank you, Professor Pedro, very much for such an enlightening conversation, presentation. Uh, I have a couple of points, but I will defer to my colleague Alberto, that I understand was able to address some of the technical issues that he had at the beginning of our session today, and also the students, right, who may have questions as well as comments. So this is your time par excellence. But first, let me pass the mic to Alberto, please.
First of all, Pedro, let me to present my apologize for having technical problems at the beginning of your lecture. I am very glad with the quality of your presentation. Our students are extremely enriched with your knowledge that you had opportunity to transmit to them. And I would like to begin this debate by asking what conception of human rights do you work with you analyze the purpose of state?
I'm sorry, can you repeat the question?
What conception of human rights do you deal with when you analyze the conception of the purpose of state?
Well, that's an easy question, and I'm not sure that I can answer, but I'll give you my thoughts on it.
Mm-hmm.
A state sovereignty, I believe, is not infinite, and it's not absolute, and I don't believe that it's territorially based. Having said that, that means that there are limits to that sovereignty. Those limits to that sovereignty can come in different ways. One, when the state openly and expressly, through its treaty-making authority, selects and elects freely to limit its sovereignty. Now, a number of states, through the American Convention, through the European Convention on Human Rights, the African Charter on Human and People's Rights, have elected to limit their sovereignty and to limit those sovereignty in deference to higher norms that they call human rights, that we call human rights, even though we understand that within that set of human rights, there are differences, as we were talking about, to be free from arbitrary killings, to be free from suffering, to be free from slavery, to the right to have a name, children's rights. These are rights that I think are completely inalienable rights. Then we can move further along and talk about other rights that people can have a difference of opinion on: freedom of assembly, access to the political system. Some people may say these are freedom of speech, these are inalienable rights. Others may say, no, they're not inalienable. They are susceptible to a number of exceptions. So my inadequate response to your very thoughtful and complex question, even though you stated it in one sentence, is that the state has to subordinate its sovereignty to human rights. that there is a hierarchy of human rights, that these general principles, of course, are not without qualification, but that certainly territorially based normative foundations for the exercise of state sovereignty has to be looked at with a lot of care, and it has to be challenged. I don't know if that helps a little bit.
Thank you very much, Pedro.
Our dear students, is anybody interested in taking the floor? So Marco raised his hand, and then Ana Carolina.
Good afternoon, Mr. Martinez. Thank you for your words. It was quite interesting hearing your presentation. And there is one aspect that I wanted to highlight. I don't know if I missed from your words, but it seems that I leave this presentation with the idea that the principle of public purpose cannot be solely based on objective principles, right? There is some flexibility to it. There is some subjectivity to it. This perhaps highlights the role of arbitral courts, right? Of arbitration in defining and quantifying, balancing these aspects that you highlight. What space does it leave for state sovereignty in this discussion, right? Where does states participate? Is it through courts? Is it through discussions inside the exceed in standards? I mean, what's the role of the state, right? Thank you.
Thank you. That's a very interesting question, and please correct me if I'm not addressing it frontally. I think the state has a huge right and a huge role in defining public purpose and in enforcing public purpose. For example, I will give you a very simple example. If you take what used to be, I guess it's still in force and under some tail theory, but if you look at Article 1101, subsection 4 of the NAFTA, the investor protection scope provision of what used to be the NAFTA, which now doesn't exist in the new USMAC or CUSMA, however you want to call it, you will see that the state parties, Mexico, the United States, and Canada, agreed on a standard for public purpose. They said the state will be able, the signatories to this treaty will be able to enforce its own laws, notwithstanding any provision of the investment protection chapter 11, that concerns health, police powers, and it goes on, such as, and it gives you an example. And it gives you about, maybe I have it right here. It gives you a few, here it is. I'll read it to you because I think it can be helpful. It says, quote, nothing in this chapter, now this chapter is chapter 11, the chapter that is tasked with investment protection, okay? The protection of foreign investors and investments. It says, nothing in this chapter shall be construed to prevent a party is one of the three signatory states, to your question, it's a state, from providing a service or performing a function such as, let's stop there. Notice that it says such as, in other words, by way of example. It's not limiting. It's not saying these 10 or these 4 or these, such as, like, 1, law enforcement, 2, correctional services, 3, income security or insurance, 4, social security or insurance, 5, social welfare, 6, public education, 7, public training, 8, health and child care, in a manner that is not inconsistent with this chapter. So the state can say, look, we think these are public purposes, these types of activities. And even though, Mr. Marco Hermano, we have an obligation to protect your investment in our country here, we can regulate that investment to the extent that that regulation has to do with healthcare, with childcare, with Social Security. And if that affects you negatively and diminishes the value of your investment, I'm sorry. I'm sorry. Bring a claim under the treaty and we'll compensate you. But this type of public purpose is a legitimate public purpose. Now, you're entitled to compensation, but because this is a legitimate public purpose, you're not entitled to 100% compensation. You're entitled to adequate compensation. Now, let's stop there for a second. Now, let's assume that instead of regulating or passing a law that hurts your investment, that looks like any of those things that I mentioned, any of those categories, I pass a law or whatever, a tax that diminishes your investment, your profitability, or altogether destroys your investment, because that tax is to fund my political party. That's not a public purpose. That's regime perpetuation. That's almost corruption. Now, at that point, you bring the claim, and now it goes before an arbitral tribunal that's international in nature, and you're entitled to 100% compensation. Compensation of where you would be from a profit and loss position had the wrongful act not taken place. I don't know if this helps.
Thank you, Professor Pedro. I'm going to pass it on to Ana Carolina. And Marco, if you want to rejoin the queue, you're welcome. Yes. Ana Carolina, and then I have two more students.
Thank you, Professor Cristiane, and thank you, Professor Martinez, for the class. It was very useful and helpful. I have a question regarding human rights, just as Professor Albert made, but regarding the suspension of guarantees as we have in the American Convention. Can we use this as a comparative to the public purpose? Because we have the possibility in the American Convention in the case of war, public danger, or other emergency. And I was thinking if we can try to use the standards that were already told by the Inter-American Court and its jurisprudence to try to think about the criteria to a possible limitation of human rights as we were talking about.
Yes, I mean, thank you. That's a great question. You know, there are a number of categories where, of course, where most or a number of human rights treaties make exceptions where some rights can be suspended. There are two things come to mind with those. First of all, those are extraordinary circumstances that I think also should be corroborated by the international community. That's number one. Number two, so that's not the case today, and that's not the state of affairs today with public purpose or with human rights law. So that's an area where we can think hard, where we can develop, where we should write articles, where we can do a lot of things. So that's a very fertile area. The second point is that even in those extreme circumstances, I think that there are a number of human rights that should not be infringed and cannot be infringed upon. And I go back to the universal definition of jus cogens. I don't think that any emergency on God's good green earth can give rise to a suspension of jus cogens, of being free from slavery, of being free from torture, of having these very basic rights.
Thank you, Pedro. I'll pass it on to Johnny, and again, Ana Carolina, if you want to rejoin the line, feel free.
Okay. Good afternoon, Professor Pedro. Thank you for your lecture. Very interesting. My question to you, actually, I have two questions. The first one, can we say that public purpose is a sort of claim to forge a convenient political, economic, social, or environmental situation? And my second question to you is, it's not a question actually, but can you explain a little bit better about legitimacy of public purpose?
Sure. Let me see if I understand your first question. Your first question is, tell me if I understood it correctly, please, and don't be shy. You're saying, gee, is public purpose really a pretext for, you know, a political, economic, social expediency on behalf of the state? Is that your question? Yes? The answer is yes.
That's correct.
Of course it is. Of course it is. And, you know, you can, the legacy, what we have today in public purpose, which again has its origins in the justification of the taking of slavery in Greek city-states. That's the origins. That's the origins, and it has not changed. It's whatever is expedient for the state. So much so that, as I tried to explain, if you look at the major cases from the ICJ and from claims tribunal globally, no one even debates public purpose because there's no room for debate. The way it's set out, it's a test that is always met. If the state says that it's a public purpose, it becomes a public purpose. So if the state says it's an emergency as a matter of public purpose, we're expropriating all properties, and there's no such thing as private property anymore in the Federated Republic of Brazil, that's it. Now, that's the state of the law today. Make no bones about it. And what I am saying, which goes into your second question, which is what is the legitimacy of public purpose? I'm saying something that may sound radical to you. I'm saying that right now, public purpose has no legitimacy because, as I've just finished saying, if a test can always be met, if there's no accountability, then that's not a test. If it's universally true, because what defines its legitimacy is who says it rather than what is said, if the who is more important than the what, which is conceptually at odds with every intellectual subject matter and category in any discipline of law or science, then that doesn't make any sense. So what are we saying? We're saying I suggested a non-exhaustive list of 11 elements that should form part of public purpose. So that public purpose must be demonstrably objective, with the burden of proof falling on the actor, namely the state, asserting public purpose as a justification for its actions.
Thank you, Pedro. I'll pass it on to Rodrigo, please.
Thank you. Thank you, Professor Pedro, for your speech. It was very enlightening for me. Well, my question, I don't know if it's a legitimate question, but if it's not, you point it out for me, please. I would like to know, Professor, and your speech reminded me a very hot debate we have here in Brazil between social function of property and individual right of property. I don't know if we can make any parallel between the public purpose and protection to international investment and this debate of social function of property and individual right of property. If so, could you make some assertions about that?
Sure. I don't know the debate in Brazil about private property or private rights in property and the social need for property, or so I don't know the particulars of that debate. Now here's the tension. As we said at the very beginning of the discussion, there is always a tension, there is always a squaring of the circle when the state has to carry out an existential task, which is legislating, regulating property and beyond, and the equally binding obligation that the state has to protect foreign investment. Now, so there's always a tension because the two are obligations that the state has, If a state does not engage in regulatory or legislative activity, a state in effect commits treason. It violates its existential obligation. But at the same time, the state must respect foreign investment, the very foreign investment that it sought to bring into the state and that may constitute the life of its economy. So both activities are necessary. The important thing is to balance that activity. And what we're trying to say is that we cannot have those activities balanced if one of the critical elements for determining that balance and rendering it fair is an element that the state unilaterally can define. It's the same thing as giving the state a license to take property from you, the individual, to build an airport, which is for the collective good and it's necessary. But then the state saying, but I'm not going to compensate you. Or I'm going to compensate you less than the value of your property. That's extremely problematic. There's an even more radical position that the state may take, which is the state may say it is existentially necessary for the state to be the solitary owner of property. There cannot be any private property because the greater good, the public purpose dictates that the state should administer so important an asset as real property. You understand, the second you give the state a formula that it can always meet and that can never be challenged on objective grounds, then the state's obligation to protect private rights is completely eviscerated. It disappears, becomes vapor.
Thank you, Professor Pedro. I have a comment and a question myself, and that comes obviously from where our class is situated, right, in the broader theme of international law and global governance. And when you talk about the public purpose doctrine, I understand that from a procedural standpoint, we may be reproducing a model that dates back from ancient Rome and ancient Greece, right? But from a substantive model, I want to believe that jurisprudence has evolved. And to speak more directly of the second half of the 20th century, right? I believe this jurisprudence perhaps is also associated to the principles of what in the doctrine we see referred to as the liberal international order. Um, and one of these principles, of course, is the protection of human rights, equality of sovereign states, and on and on. But that in itself has has brought up some problems for global governance as we have it today, in that multilateralism and international cooperation, which happens to be one of the pillars of this very same liberal international order, is now being challenged, right? So I wanted to prompt you a little bit to talk about the idea of yes, a public purpose doctrine, but one that would relate to to global governance or to the international community per se, and not so much to individual states, and much less yet to this liberal international order, right? Because what we see in the scholarship is saying, look, this liberal international order was designed to protect the interests of hegemonic states. And to the extent that it survived, yes, non-hegemonic states did play a role. There was a lot of contestation, and there's still a great deal of contestation. I am not fluent on your topic today of investment disputes to be able to say whether the contestation compromises, right, the identification of some objective traits in the public purpose doctrine or not, right? But as you were talking, I couldn't help but remember another talk, and coincidentally by another NYU law professor, Professor Jeremy Waldron, uh, in the context of the torture memos, right? So it was a lecture on the prohibition of torture. And of course, he brought the example of the torture memos to now picture this hegemonic state, one of the architects of the very same liberal international order, right, that was now involved in the business of attempting to justify torture. Of course, this has all been resolved from a legal scholarly point of view. But I always go back to that talk, and I have shown it to my students because in there, what Professor Waldron does, right? He tries from a political, philosophical standpoint rather than a legal standpoint, right? To argue that the prohibition of torture is indeed absolute, not because it's part of Jus Cogens, but because it is wrong, fundamentally wrong, yes? So I'd love to hear you a little bit more on this possibility of a public purpose doctrine that is, yes, objective, subject to the burden of proof, and so and so, but that belongs to the realm of the international community per se. Uh, and, and in that being, it is detached, right, from any particular state, hegemonic, non-hegemonic.
Yeah.
That's my question.
Yes, thank you. It's an excellent question. Look, I don't know if I can do that, but I can try to give you some examples of public purpose in beyond perhaps just the narrow field of the public international law of investment protection. But before I do that, one of the things that I wanted to do was to emphasize that the way I'm looking at public purpose is precisely free, to some extent, free or predominantly free from territorially based elements. So that's point number one. So when we're talking about micro, macro, proportionality, distributive effects, chilling effects, these are theoretically, this should be very much tied to more than just national considerations. But here's where I see public purpose in a multilateral context, more broadly. I think that public purpose helps in the development of a transnational law. A law that says the only way in which we can solve problems, international problems, is through multilateralism, because the solution to those problems itself is the overriding transnational public purpose. For example, climate change. Climate change is a problem that all states have. Climate change is an existential problem. Climate change has to be addressed. Addressing that climate change is an imperative of public purpose. How it is addressed, however, by the community of states has to be completely, as I said, along the lines of the 11 non-exhaustive elements that I set forth. Let's look at another global problem, a problem that cannot be solved by any single state or small group of states: human trafficking. Human trafficking is a problem that belongs to everyone and no single state in particular. That there must be a solution that is multilateral in nature to human trafficking, of course, it is I think, unassailable proposition. Of course, you find people who argue anything, but I believe it's an unassailable proposition. Now, how this is done and how we can enlist states to contribute, again, this is an overarching public purpose transnational response that has to be objective in nature. And we can go down the line and add corruption and add all of these problems that at the end of the day, corruption, for example, I think at the end of the day is responsible for the very fact that a child dies every 27 seconds from a curable disease and every 36 seconds from hunger. Now, that's a problem that we all have. And to the extent that we didn't address that problem, we're compounding and creating other problems. These are problems that can only be addressed through multilateralism. But what we ask states to do and how we ask them to do it is a question of an objective public purpose doctrine that doesn't exist. I mean, that's one way in which I can try to address, a recontextualization of public purpose.
Pedro, prior to finish, Cristiani and I and our students, all of you are particularly grateful to your generosity, and we sincerely expect that this is the first opportunity of others that you can have to exchange mutual ideas and to become more solid and even strengthen the contact between our institutions.
Absolutely. Thank you so much. I very much look forward to staying in touch, and I invite any and all the students to please feel free to reach out. I have a moral obligation to try to address your questions, and I would look forward to doing it. I do this all the time with students throughout the world. So thank you. Thank you, Cristian. Thank you, Alberto. And
thank you very
much. Students.
I join Alberto, Professor Pedro, in thanking you and hoping that, again, this is going to be the beginning of a really productive collaboration. And from our end, you should know that we are here and available also to engage. And we'll be delighted to, speak to you about forthcoming projects and courses next year. Yes?
I would love to.
We can cooperate in projects in common.
Absolutely. It would be a privilege.
And to our students, I would like to say that we're going to take a 5-minute break and be back just amongst ourselves, to continue the conversation. Yes. Pedro, thank you again.
Thank you.
Please be well.
You too. Bye.
Goodbye.
Thank you, professors.